The end. Whether it's a film, TV show, opera, or football game, when it's done, it's done. You may have had a judgment go against you in court and thought the same exact thing. Well, when it comes to the law, it ain't over till it's over, unless it's not over. Because action can be taken to make a judgment or ruling null and void, like it never happened. This is called vacating a judgment. And needless to say, it's not something that can happen without legitimate proof. A judgment is the court's final written determination of the rights and obligations of the parties in a case. It is defined as a definitive act in a lawsuit that ends the litigation by ruling in favor or against the plaintiff's claim. If you have grounds to vacate this judgment, you must file a motion to do so within a reasonable amount of time. In Florida, the time limit for most motions to vacate is 1 year after the date of judgment. Simply filing for a motion to vacate does not in and of itself have any effect on the judgment or its consequences. There are a few specific reasons a ruling can be vacated if proven. One is if there was a mistake, negligence, or surprise during the case. Another reason for vacating a judgment is if newly discovered evidence comes to light. This is one of the most difficult to win, however, because you will need to show that the evidence really is new, not just something that you missed because you weren't looking hard enough. Another reason for vacating a judgment is if the opposing party committed fraud, misrepresentation, or misconduct during the case. Or you can vacate a judgment if you have already paid off or settled that judgment or an earlier judgment that one is based on. In case of a default judgment, you can vacate the judgment if you can show that you were not properly served with notice of the case and that you had a good defense. If you are looking to vacate a ruling, check out Legal U to see if you have the grounds to do so. Legal U. You can do this.